The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to the Kansas Supreme Court. We'd like to welcome, we have several visiting judges I'll mention in a moment, and we'd also like to welcome all of you who are watching us through our Supreme Court Live channel. Before we begin today's proceedings, I want to take just a moment to note that today ends an era of our court. That is the era on which Carol Beyer sits as a justice of our court. Today marks her retirement. Because of the current public health situation, we are not going to be holding a public event where we would publicly thank Justice Beyer for her service. She has served admirably the court, the judicial branch, our profession, even at a national level, and certainly all Kansans. So we can't let this day pass without at least a short tribute. And so I'm taking advantage of this venue to make a few just very quick public remarks. If we were in person, you would have to listen to me for much longer. And if so, I would hope I could do a more adequate job of trying to describe the incredible service that she has provided to the court and to the people of Kansas. But just briefly, let me note that on September 5th, Justice Beyer marked the anniversary of her joining the court 17 years ago. Before that, she had served 3.5 years on the Kansas Court of Appeals. According to a quick search I did on Westlaw, she is the authoring judge or justice of almost 400 appellate decisions. I think it's fair to conservatively estimate that she's participated in the court's disposition of more than 15,000 appeals. Let me tell you that with Justice Beyer's work ethic and commitment, each of those appeals was carefully considered by her, and they were viewed through her unwavering lens of seeking justice. She said steadfastly adhered to the rule of law, uninfluenced by outside pressures, and she valiantly protected the role of fair and impartial courts, a role so essential to the protection of our freedoms and to the achievement of the ideal of equal justice for all. Her writings create a body of work, a true legacy of a jurist who crafted clear, well-reasoned, and masterfully written opinions. Her questions posed to counsel during argument and to justices during conference revealed the rigorous analysis she applied to every question. On the administrative side, she has led many projects that will leave lasting improvements to the court system. Overall, she has continuously pushed to better the system and to improve the conditions for all of the employees of our judicial branch. She has constantly and consistently moved us forward. Let me just say, her contributions and her leadership will be greatly missed. On a more personal level, those of us on the court will miss the opportunity to day enjoy those conversations with her that were peppered with wit. We will miss her insight, her knowledge, her analytical skills, her wordsmithing, and so much more. Yes, as I said, she will be greatly missed. But she keeps reminding us that she will be actively pursuing other dreams and passions. We wish her many more of those achieved dreams, great happiness, and the best in her new phase of life. And as we mark the end of that era, as I've said many times this week, we are also welcoming in a new era. And that is the new era of having our newest colleague, Justice K.J. Wall, sitting on the court with us for his first docket. Today, he ends that first docket. We're very pleased to have him serving with us. And we've been very pleased all week to be ably assisted by Senior Judge Ward, who is setting, since Justice Beyer is not sitting with us this week. He has been assigned as a senior judge to our court since March of this year. Previously, he served as a district court judge in the 13th Judicial District. On our first case this morning, we do also have two other justices who have recused, and so have two visiting judges. I thank both of them for their service to us today. First of all, let me introduce, excuse me, District Court Judge Jeff Elder. Judge Elder has sat since 2008 in the 2nd Judicial District. He primarily hears cases in Pottawatomie County, but also covers matters in Wabaunsee, Jackson, and Jefferson counties, which are the other counties in his judicial district. He is sitting today in place of Justice Rosen. Also recused is Justice Wilson, and we have sitting for her today, Judge William Mahoney. He was appointed to the bench in 2010, and he hears cases in the 29th Judicial District, which is Wyandotte County. Both of these judges come to us from busy dockets. They've taken time away from their own caseload to help us out, and we greatly appreciate their assistance with us today. Each of the visiting judges have read the briefs, like the other members of the court. They will participate in our deliberations and continue through the decision making in this case. So again, to both of you, thank you. We appreciate your service every day, but especially today, we want to thank you. With that, I will ask the clerk of the appellate court, Mr. Doug Shima, to please call the morning's case.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Friday, September 18th, 2020 consists of one case. Appeal number 118307 in the matter of the estate of LANNY LENTZ, Shawnee County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, I'm Jonathan Sternberg and I represent the appellant Diane Wyatt.
Good morning. May it please the court, Aaron Bailey on behalf of Appellees Marilyn Lentz and Lana Kennedy.
Thank you, counsel. Mr. Sternberg, you may begin your argument.
Thank you, Your Honor. Again, I'm Jonathan Sternberg. May it please the court, I'm Jonathan Sternberg and I represent the appellant Diane Wyatt. This is a probate estate appeal. Ms. Wyatt appeals from the final settlement of the estate of her late father, LANNY LENTZ. The appellees are her two sisters, Marilyn Lentz and Lana Kennedy, and Ms. Lentz is the estate's executrix, which is the person who's in charge of the estate, in charge of managing it while it's still open. Ms. Wyatt appeals from the final settlement, challenging the sufficiency of the evidence to support the district court's findings of value of 4 residential real properties in the estate. The Court of Appeals dismissed her appeal on jurisdictional grounds and then held that even if it engaged in appellate review of what she asks, it would affirm. And this court then granted review, and that's where we find ourselves. Your Honors, the Court of Appeals' reasons for dismissing Ms. Wyatt's appeal, as well as both of its reasons why it would affirm, were error. Her appeal is timely and proper, her challenge is preserved for appeal, and the district court's findings of value are indeed unsupported by substantial competent evidence. This court should reverse the Court of Appeals judgment, reverse the district court's judgment, and remand this case for a new hearing on the final settlement of LANNY LENTZ's estate. First, the Court of Appeals held that Ms. Wyatt's petition for reconsideration, she called it a petition to set aside and or reconsider the lower court's judgment, which she filed within 28 days of that judgment, didn't toll the appeal time for the standard 30-day appeal time because the motion also sought to set aside the judgment under 6260B, which made her notice of appeal untimely. This was error. Your Honors, in the Honeycutt case in 1992, this court squarely held that asking a district court to reconsider its ruling within the period for an authorized post-judgment motion, which today, of course, is 28 days, qualifies always as a motion to alter or amend the judgment under 259F. And in every single case in the more than 25 years since then, in which a party filed something within that post-judgment motion period, asking the district court to reconsider, no matter how perfunctory, no matter how poorly worded, no matter if even called something else sometimes. And we list every single one of those on pages 6 and 7 of our supplemental brief in this court. In every one of those cases, this court or the Court of Appeals held that it qualified as a motion to alter or amend and told the appeal time. In fact, in the INDA case from the Court of Appeals in 2013, it was even just as here where the motion cited 6260B. And your honors, this makes sense. This court time and time again for decades consistently has held that the right of appeal is favored by the law. It won't be held to have been waived except on clear and decisive grounds. In the Mundy case just 2 years ago, this court held that, quote, where there is a valid controversy whether the statutory requirements have been complied with, this court is required to construe those statutes liberally to assure justice. And jurisdictional rules, of course, should be read to allow the litigants to have an opportunity to have their claims heard. Ms. Wyatt clearly did not intend to waive her right to appeal. Her motion was, yes, Your Honor.
What, is there a substantive difference for the grounds for relief under 259 as opposed to 260B? Or instead, is there substantial overlap?
I think there is substantial overlap. In fact, it's an interesting thing that the law of Kansas even makes this distinction, because in Missouri, we have an identical rule, because these are all based on federal rules, of course. We have an identical rule, and our Supreme Court has held that it's actually a motion to set aside a judgment filed within the post-judgment motion period itself qualifies as a post-judgment motion. So there is substantial overlap. You're asking for the judgment to be undone in some way, to be reconsidered, to be set aside, because obviously if it's reconsidered, then the judgment is undone. It is set aside and a new judgment is entered, or a new trial perhaps is ordered. But under 260, it's set aside for various reasons that are enumerated in that rule: excusable neglect, surprise, mistake, fraud, that sort of thing. And here, I think by putting the word reconsider in the motion's title and then asking that relief be accorded, my client's trial lawyer was clearly trying, and filing it within 28 days, of course. My client's trial lawyer was trying to ensure that this could be continued, the appeal time could be told. What the appellees are asking for, and what the Court of Appeals did effectively, is to play a game of gotcha. For the first time ever, they didn't file a motion to dismiss the appeal after we filed the notice of appeal. And the notice of appeal clearly says we're appealing from that earlier judgment, not this request to set it aside. But we're appealing for that earlier judgment. Only for the first time in their brief in opposition to ours in the Court of Appeals did they raise this argument that, oh, well, actually, we never had the right to appeal in the first place. So the law of Kansas doesn't play gotcha. There's no cases, especially since Honeycutt, that play gotcha. This was clearly error. Next, the Court of Appeals held that regardless, it would affirm the trial court's judgment because Ms. Wyatt hadn't objected to the findings in the journal entry she now challenges, making her arguments not preserved. And this is obviously.
Counsel,
yes,
let me just ask a preliminary question on that point.
Yes, Your Honor.
You characterize that as a holding. Can that actually be a holding when the court first says it doesn't have jurisdiction?
No, I guess it's dicta, essentially. I think what the Court of Appeals judges were trying to do, Your Honor, was shore this up in case Your Honors disagreed with them on the jurisdictional issue.
They applied a common tactic of belt and suspenders here, but when the belt is we don't have jurisdiction, my question is the alleged finding on the merits even before us?
Well, this court granted review on all three of my questions, and one of them is whether it was error for the Court of Appeals to make that holding in the first place. So to that extent, yes, Your Honor, I think under the rules, this question is before Your Honors.
I guess I can rephrase it. Should we consider that question when the lower court said it did not have jurisdiction? In other words, why wouldn't our work be done if we agree with you that the Court of Appeals erred in finding it did not have jurisdiction? Why wouldn't that end our work? And we would send it back and essentially disregard the Court of Appeals dicta on the merits.
Well, because it is something that's in the Court of Appeals decision. And, if the court were to leave that be and just limit its decision to the jurisdictional issue, assuming the court agrees with me on the jurisdictional issue, future courts would still use what the Court of Appeals held as precedent. Unless the court firmly says that it's not. But I think in the interest of judicial economy and and this court has the jurisdiction to consider anything that the Court of Appeals stated in their opinion. I think these issues are before the court, and that's why the court granted review on them. So that's it's certainly something in front of the court, and it is obviously wrong. 6252A4 clearly says that a party can challenge the sufficiency of findings in a judge-tried case, even if they didn't object, even if they didn't request findings. This court held so in the Marriage of Bradley case. The other side's only response is that we're arguing inadequate findings. So, where that the trial court made inadequate findings. That's not true. That's only when, and there's a recent case from just a couple weeks ago in the Court of Appeals, Marriage of Pogge. It's case number 121012, came out September 4th. It explains this distinction pretty well, that inadequate findings are where you're saying that the district court should have made findings but didn't. You have to have requested those findings. But when you're challenging findings the district court did make to determine whether they had substantial evidence to support them, you don't need to preserve that through some sort of special litany on appeal. So that was wrong too. And finally, the Court of Appeals held or stated in their opinion, in their belt and suspenders approach, that the values Ms. Wyatt challenges were supported by a supposed appraisal outside the record that the executrix claimed to have circulated after trial. The court granted review on this as well. And this is also obviously wrong. In fact, so wrong that the appellees don't even try to defend that in their response. Materials not introduced into evidence, especially those from after a trial, aren't substantial evidence on which a finding of value of fact can be predicated. We have a series of cases, page 14 and 15 of our supplemental brief, that explain that. Instead, Your Honors, with the appeal timely and proper, Ms. Wyatt's challenge preserved, and the court's inquiry limited to the evidence before the lower court, clearly there was no evidence that supported the trial court's ultimate findings of value. I would point the court to a chart that we made on page 24 of our Court of Appeals brief that cites the record and illustrates exactly what the evidence was. Even if you take just the executrix's own testimony as substantial competent evidence, which we argue it's not, because there's case law that says you have to have certified appraisals and there has to be somebody who is competent to testify about those appraisals. But even if you take just her testimony alone, it's still outside what the range of the value she testified. For example, on one of the properties that had been Mr. Lentz's residence, the lowest valuation she ever gave of it was $55,000, but the trial court valued it nearly $20,000 less at $38,000. I mean, those kinds of errors.
Sorry, I'm sorry for that. Do you have an issue with the valuation of 613 Lindenwood, however?
Yes, we do. 613 Lindenwood, the highest valuation she gave of it was $39,000. The trial court valued it above that at $41,000.
And so the December 2015 accounting, I believe, valued it at above 60. Is it appropriate for us to consider that evidence?
Well, so that's an interesting thing. The December 2015, she kept changing these values. So in December 2015, she said 605 is worth $83,000. That's probably more correct than ultimately what happened. But then suddenly she changes that to 55 in 613 to 30. But in her testimony, she said, no, it's actually worth $39,000. That was the highest valuation she gave. It's still her burden, regardless of the statute that the court asked us to brief 59-1202, regardless of what she puts in her inventory, it's still her burden to prove these valuations. This court has held that time and time again, most recently in the Hierstead case from 2008. There are a couple other cases that are older, the Engels case from the Court of Appeals in 1984. It's her burden to prove by substantial competent evidence what these values are. So yes, we have a problem with all of these values. First of all, they aren't, her testimony alone is not substantial competent evidence. And second, the only testimony she gave of 613 Lindenwood, the highest was 39. The trial court valued it above that at 41. Seeing I only have 10 seconds left, I would leave the rest for rebuttal unless your honors have questions.
Oh, I do have one question. Sure. It appeared that the trial court adjusted the value of 605 Lindenwood because of costs of repairs. I was not clear whether that was the adjustment that was made on 613 Lindenwood.
Okay, so for the cost of repairs, her appraisal, including a repair on 605 is $55,000. That's record volume 3, pages 10 to 12. So it's 55, and the trial court's value is 38. So the lowest value she ever gave her was 55, and that included the repair. On 613, her alleged value, including repair, is $34,000. That's record volume 3, pages 30, I believe, page 38, possibly page 12 or page 38, but it's 34. And again, the trial court's findings say it's 41. The real problem here, Your Honor, is that, and I wish the court had some way to listen to the oral argument that was made in the Court of Appeals, because my opposing counsel flatly admitted this, that these were to equalize the shares of the estate. These values were made post hoc based on no evidence at all, so that the equalization could be perfect. And that's not how the law works. The law has to, make a finding, it's a search for truth, and the findings have to come after that search for truth, not before.
So these values that were the 41,098 and the 38,787 were proffered by counsel, or were they derived by the judge's finding?
It's not clear from the record, Your Honor. That's one of the problems here with that third issue about, the Court of Appeals holding there was some certified appraisals circulated by counsel to other counsel after trial. I'll note that my client's lawyer didn't sign off on that final judgment at all. And Your Honor, I've never seen this alleged appraisal. My client has never seen it. It's not in the record. It's not something that can be considered. I think what happened, though, is the parties just proposed that to the judge, and the judge signed it, and the law doesn't allow that.
Counsel, with respect to 613 Lindenwood, did you consider that value of $41,098 appears to be, it's not exactly, but it appears to be close to an average of those three values? And if it is an average, is there anything wrong with a district judge taking three values given to him or her and simply using an average of those values?
Yes, Your Honor, there is. Here, those statements of what the executrix believed these were worth in her inventory are just her statements. That's still not substantial competent evidence. And at the end of, when there's a rule of civil procedure that whenever you file something amended, what happened before goes away. Here, she was saying that in her estimation, as of the time of the trial, the value of that was $30,000. No, the court cannot consider averages if she didn't testify to that. Whatever she put in her pleadings before, those aren't evidence. She still has the burden. It's the Hearstate case from 2008. She still has the burden to prove by substantial competent evidence at the hearing what those values are. Thank you, Your Honors.
Are there other questions, counsel? Okay, thank you, Mr. Sternberg. Mr. Bailey?
Good morning. May it please the court. Thank you for the time. The reason why we're here is that Mr. LENTZ wanted his real estate to be divided in kind to his three daughters. Before he passed, he gave a roadmap for how that would happen. And that's eventually, after a protracted litigation, what happened in this case. To get to the threshold issue of whether substantial competent evidence is even needed, we have to get through two jurisdictional issues, which we cannot pass those. The first jurisdictional issue is whether this is a 259 motion or a 260 motion. And those are distinguishable. They are distinguishable by law. They are not blended. If we conflate a 259 and a 260 motion, we are rewriting the statutes. We are rewriting 6206 and 602103. We can't do that. I understand.
What's the difference between the two motions in terms, if they provide substantially the same grounds for relief, other than the timing, how do we distinguish between the two types of motions?
Well, they're based on two separate grounds. And the Court of Appeals in their decision kind of spelled that out about why the legislature decided to differentiate the two. And
well,
the two,
how do they differ? I mean, 260B has a catch-all in B6 that, or any other grounds.
Well, the Honeycutt case is not controlling here. The controlling case is Tenek and Heim v. Worth, which clearly hold that when the court is analyzing whether it should be considered a 260 or 259 motion, you look through form to the substance of the motion. What is that motion asking for? This motion, or this petition to set aside the judgment, was asking to set aside the judgment to the extent to pursue damages against one of her sisters. That's what it was asking for. That is not something that was held in the decision that was asking to be reconsidered. So the difference between the two is when you're filing a 260, you're asking the court to correct its own errors. When you file a 259, when you file a 260 motion, that's because of party's mistake, fraud, as Mr. Sternberg said, there's different reasons. So a litigant should not be punished when they file a motion asking the court to reconsider its own decision, because it's the court's decision. It's not based on what the party did or what the party found new evidence or the party was defrauded. So there is a clear difference. And so we don't need to look at federal law. We don't need to look at Missouri law. It's very clear. The statutes, yes, should be liberally construed to preserve appellate jurisdiction, but you cannot ignore the plain text of those statutes. And they're differentiated for a reason. Tenek and Heim v. Worth clearly spelled that out. Honeycutt and all the other decisions cited by the appellant, the unpublished decisions, give very scant analysis to this. But the question is, what is the motion asking for? And here, it was not attacking any finding in that journal entry of final settlement. It was trying to go after damages. And it was based on purely the party's mistake. And at that hearing, it was solely focused on the appellant getting bad advice, made a mistake, and wanted to pursue those damages. So that's the difference. So that's the first jurisdictional hurdle we have. The second is what the court asked for supplemental briefing on. And that's whether 59-1202, not invoking that statute, waives the right to challenge valuations. And it does. As spelled out in our brief, 59-1201 and 59-1202 make it clear that valuations of personal and real property in an estate is determined by the executor, the personal representative. 59-1202 says no independent appraisal shall be made of that valuation unless the party requests an appraisal. And that's important. No independent appraisal shall be made. Independent of what? The executor's determination of those values. The court does not decide what the values are in an estate. The court merely approves what the executor proposes. And that's what happened here. And at that hearing, the appellant for the petition for final settlement requested that the executor use the CMA valuations. And that's what happened. Following the court's order, the executor proposed those valuations in the journal entry for final settlement. And that's what was ultimately approved by the court. But there is no jurisdiction for a court to determine the valuations of a property. And I know that seems odd, but that's what the statutes dictate, and that's what the statutes tell us.
Does that statute define the powers of the executor, however?
Well, when we're
to the court.
Well, when we're talking about valuation of property, 59-1201 and 59-1202 are what guides that. And see, the cases that the appellant cites for saying, oh, well, we need to prove substantial competent evidence goes to an accounting. Those are two separate things in an estate. An accounting and valuation are two separate things. So it makes sense that if I'm going to provide an accounting of the estate and say, well, money was received, I paid a bill here, I did this, and one of the heirs says, well, I want you to prove that you paid that bill. That makes sense. But valuations are separate. That is a separate, distinct operation of what the executor controls, and 59-1201 and 1202 tell us that. And so, but despite ample opportunity for the appellant to request an independent appraiser, that was never made here.
And if we adopt that construction, does it matter? Because is there a difference between challenging whether there's substantial competent evidence to support the judgment as opposed to contesting valuation through an independent appraisal?
I believe so, Your Honor. And that's because the executor's valuation controls. End of story. If you don't like that, you request an appraisal, and then that appraisal controls.
Right. But I guess my question is a challenge to the sufficiency of the evidence does it even implicate this statute? It's testing in other words, if you're testing the ultimate judgment versus the evidence in the case, how is this statute implicated?
How is 59-1202 implicated?
Yes.
By requesting an appraisal, period. And you could have done that on a motion for reconsideration. You could have done that at the hearing for petition for final settlement. At any time, that's what you could have done as far as the valuation issue. If you're challenging an accounting, sure, then we can say substantial competent evidence was needed. But the court has no jurisdiction to an appraised estate, which was clearly laid out in re words, where the court, this court clearly said the district courts have no jurisdiction to appraise an estate itself, and to do so would have been an error.
You keep using the word jurisdiction, and I really, and perhaps that's been sloppily used in opinions, but I really question that it's a jurisdictional issue. We have tried to clarify that the jurisdiction of the court comes through the Constitution, and that is the source of jurisdiction. It seems like perhaps it would be more aptly worded, and I think this goes back to Justice Wall's point. It's really more of an evidentiary issue of what is competent, the definition by the legislature of what evidence can be competent to prove. And so perhaps what it is that the executor's appraisal is the only competent evidence unless this procedure is followed. If I am persuasive in that, do you have any issue with that type of analysis? Do you see any flaw in that flow of analysis?
Yeah, and I guess that would be a way to look at it, is whether the court is evidence even needed for that issue. We call it jurisdictional. I believe it is, because yes, courts are enabled by the statutes and the Constitution. But whether evidence is needed for a particular issue is clearly controlled in this case by 59, 1201, and 1202. It's not. There is no evidence needed. It is the values or what the executor says they are. End of story. So when we say, is that the evidence that we need? Is that those are the proposals that were made by the executor? That's what they are, and that is what the court accepts and makes its determination of the distribution of the property on. So I guess when you say jurisdictional versus evidence, I wouldn't have an issue with that, but that's what we're getting at. Do you need to prove valuations with evidence? No. And that's exactly what the statutes say. And there's reasons why I spelled out in our brief why the legislature chose to go that route. There's a reason why when we make a will, we pick our executor, our personal representative, because that is the person that we think will do the best job marshaling the estate. Mr. LENTZ in this case picked Lana. If not Lana, then Maryland.
What if a judge is confronted with a situation where there is evidence in the record that conflicts with the evaluation of the executor? Let's take an example that you have a bond, and for whatever reason, the executor places a value below the face value of the bond. What happens then?
You get an appraisal. And
can the judge do that sua sponte?
I would think not. I mean, if you look at the statutes, no, it needs to be requested by an interested party. And I think you're referring to the In re Parks estate case, which we talked about that. But again, that case was decided before the current probate code, number one. And number two, there was no analysis of that. Now, in that case, if the valuation of a bond or some stocks is at issue, then an interested party should say, hey, the executor shouldn't value that. Let's go get a professional opinion. And that's exactly what's contemplated by 59-1202. That didn't happen in re Parks, and that was a different statutory scheme. And honestly, the court really didn't even look at the valuation process in that case. A more better example, I think, was the In re Works case, where the court said, hey, if there's a dispute to the real property, I'm going to appoint 3 appraisers, and that's what happened. And that's how the property was valued, which is exactly what's contemplated by the statutes. But again, to even get to that threshold, and I call it a jurisdictional issue, but to get to that issue, we still have to get through the 260, 259 issue, which we can't. And this court should not ignore its clear language in 10-Eck and Heim v. Worth. It's clearly saying, look through form to substance. There's already a decision that's out there that addresses this very topic. So if you use that analysis with the petition to set aside the journal entry to the extent to pursue damages against the other sister based on that party's mistake, it's clearly a 260 motion. Now, is there overlap? Justice Wall's question? I don't think so. And if it doesn't make sense or it seems odd, we still need to follow what the statutes say. The legislature differentiated the tolling for a 259 and a 260 for a reason. So we cannot conflate those two motions. And maybe a pro se litigant, maybe a little different. We don't look at the caption. We don't say, okay, well, it says reconsider, so it's a 259 motion. It doesn't matter if they cite a statute or if they call it something. It's what are they asking for? That's the key question about whether it is a 259 or a 260 motion. Look through form to substance, clearly spelled out in the 10-Eck case. But I do want to, I'll leave it open for questions because I know I've got just a little bit of time left. But I also want to talk about the policy of why that the 59-1202 makes a lot of sense. And again, that goes back to the personal representative is either appointed by the court or appointed by the decedent. So that should carry a lot of weight. And so it makes sense that that executor has the complete authority to determine the valuations of the property. And there certainly is a way to challenge that. If you don't like that, you request an independent appraisal. It's very clear. And again, I think, this goes back to the question of what was the appellant asking for? The appellant was asking for a consistent appraisal method, the CMAs to be used, which is exactly at the hearing. And that's exactly what she did when she proposed the journal entry to the court and was adopted by the court. And again, to go back to what evidence is needed, it's not really evidence, it's what does the executor place the values of that real estate. Doesn't need to be proved by evidence. And I do want to stress that the cases in Ray Parks, Malo, some of the others, they're mainly dealing with an accounting of an estate or whether all the property is included in the estate. So we can't use this scant little dicta saying that, and using parentheses to say, well, that should attach to valuations as well, because it's not. It's separate, and we have a statute that controls that, 59-1202, 1201 and 1202, which gives the executor control of those valuations.
Are there any questions of counsel?
Counsel, I guess my question is, a lot of times it's really difficult for counsel in this situation because you're trying to summarize a pretty complicated fact pattern. I understand that. But my question is that your last comment was about using these CMA values, but we don't really, if you look at the record, there's really no record as to what those were. And I guess my question for you is you say that a judge can't value anything and it's all up to the executor and their valuations. But in this case, it just doesn't appear to be clear what those were. You have one counsel saying that none of that was even presented until after the trial. And so if you could kind of address that, that might be helpful.
Well, and this is a very complicated factual situation, but if you look at the journal entry for final settlement, which was circulated, if you look at the signature pages, I signed it. I remember getting it, and I signed off on it. So it was circulated, and the CMAs were circulated. And if you look at the Exhibit B to the petition for final settlement, it does, or I'm sorry, Exhibit A, it does say that those CMAs were circulated. And that's exactly what the court wanted. The court basically said, okay, well, I'm going to agree with the appellant and use that valuation method, and then I'll approve the journal entry, which is essentially what happened. So again, there's not a need for evidence. I guess what we call evidence, it's what were the values proposed by the executor. And that's what she presented to the court and what was adopted by the journal entry for final settlement.
Any other questions? Thank you, Mr. Bailey.
Thank you.
Mr. Sternberg, you reserve 3 minutes.
Thank you, Your Honor. I'll try to do this in 3 minutes. I want to address 59-1202 to start with. It does not change the law that the executor still has the burden to prove that the accounting in the final settlement, there's no difference between an accounting and a final settlement. It's the values of the final settlement are correct. The Engels case from the Court of Appeals in 1984 squarely holds the executor, quote, has the burden to prove his final accounting is correct. The Hart case from this court in 1951 holds, quote, in making her final settlement in the probate court, the burden of proof is on the administrator of the decedent's estate to show the correctness of her final account. And the Hiersted case, which is also a final settlement in 2008, the court held, this court held that the valuations themselves have to be based on substantial competent evidence. 59-1202 is not located in the portion of the probate code dealing with final settlements. It's in the portion of the probate code dealing with the initial inventories of the estate. I appreciate that that what the executor puts in that inventory is important and can help inform the court later. But at the hearing, it still has to be based on substantial competent evidence. But even if the court, and this is the curious thing in this case, even if the court agrees with my opposing counsel when he just said verbatim, the values are what the executor says they are, the values that are in the final judgment are not what the executrix said they were at the hearing. And that's the chart on page 24 of our Court of Appeals brief. These values that appear in that final judgment appear for the very first time only in that final judgment. They aren't part of her prior inventory. They aren't part of her testimony at the hearing. And they certainly aren't part of any certified appraisals that she testified to. Whatever was circulated after trial, this court can't even consider it. It is not part of the record because we didn't have the opportunity to scrutinize it. For example, we cite one case where if you're going to say that that's a certified appraisal, we still have the ability to look at the appraisal and say, well, were those properties comparable? Does this appraisal itself count as substantial competent evidence? Also, who is testifying to it? So 59-1202 doesn't change the burden of proof that the executor of an estate still has and always has had at the final settlement itself. I also want to address briefly this jurisdictional thing again. The two cases that my opposing counsel just cited, Ten Eyck and Heim, are very old. Ten Eyck is from 1966, Heim is from 1974. This court has not followed them, nor has any court ever since in holding that something asking a trial court to reconsider its judgment, and this does say reconsider, it's about what did my client intend, and what they intended to do was have a post-judgment motion that would toll the time to appeal while they could make the argument that they were making. And I see that I am finally out of time. We'd ask the court to reverse both lower court's judgment and remand this case for a new hearing.
Are there any questions from the court? Thank you, counsel, for both of you for your arguments today. The court will take this matter under advisement, and the court is in recess until 11 a.m. Thank you.